because we do like to finish right at 1. So welcome everyone. Thank you so much for joining us for our Lunch and Learn on current tribal sovereignty legislation. Today we're honored to have Hinton and John Banks present. Corey is a citizen of the Passamaquoddy Tribe enrolled at Pleasant Point and an attorney with Drummond Woodsum MacMahon. His practice focuses on the representation of tribal nations and their enterprises. John Banks is the director of the Department of Natural Resources for the Penobscot Indian Nation. I've had the pleasure of working with John on fights to protect our natural resources, like defeating weak metallic mining regulations. Corey and John will give an overview of LD 2094, legislation pending before the legislature, and focus on the fish and game and environmental aspects of that legislation. My name is Beth Ahern, and I am the Director of Government Affairs for Maine Conservation Voters. Maine Conservation Voters protects Maine's environment and our democracy by influencing public policy, holding politicians accountable, and winning elections. We have a few technical notes for you. This event is being recorded and will be posted on our website. We will send you all a link to the recording later this afternoon. We want to hear from you, but you are all muted. Please send your questions through the chat at the bottom of your screen, and we will ask them at the end of the presentation. If you're having technical difficulties, please message Will Sedlak through the chat function at the bottom of your screen as well for help. We will first hear from Corey and then John. After that, I will talk briefly about how you can take action to help the tribes in Maine, and then we will have question and answers. Finally, at 1, or close to 1, I will announce Maine Conservation Voters' next virtual Lunch and Learn event. Thank you again for joining us, particularly on this beautiful day. Corey, I will now turn the screen over to you.
Thank you so much. I'm so happy to be here. I really appreciate the opportunity to be hosted and joined by my colleague, John Banks. I appreciate the opportunity to connect with all of you out there. I have a short PowerPoint presentation that I'm going to pull up here right now, and I'm going to go through some slides. And I apologize in advance if there are going to be any technical glitches. Just bear with me for 1 second as I pull up slides. Okay. We're going to be, can everyone see that, by the way? Can I get a thumbs up? All right. Quickly, we're going to be going through an overview of the 22 task force recommendations and LD 2094. The 22 task force recommendations were a result of about 6 to 8 months of effort between tribal and legislative leaders that resulted in the recommendations embodied in the legislation now labeled 2094. We're going to also talk about how LD 2094 would involve the implication of certain federal Indian legal rules in the environmental realm and in the realm of the taking and fishing game. And then after that, we'll turn it over to John for a discussion on how the bill, if passed, would be enacted, at least from a Penobscot perspective. So quickly, a little bit of overview. The tribal leaders in Maine from the 4 federally recognized tribes, Passamaquoddy, Penobscot, Halton Band of Maliseet, and Aroostook Band of Micmac, were invited by Maine legislative leadership in early 2019 just to start discussions about changing the Settlement Act. That led to a joint resolution of the legislature that created a task force to examine and recommend changes to the Maine Implementing Act, which is the state law part of the overall Settlement Act, which also included a federal legal component that more or less authorized the state law. The task force met between July and 2019, pretty much through the end of the year, and covered the areas of criminal jurisdiction, fish and game, land use, natural resources, tax and gaming, civil jurisdiction, the application of federal laws passed for the benefit of Indians that were blocked in Maine because of the Settlement Act, and the acquisition of trust lands. In general, the task force recommendations would dramatically overhaul the jurisdictional allocation between the tribes in Maine and essentially enhance tribal sovereignty, enhance the tribe's ability to exercise their sovereignty on matters involving activities on tribal lands, and more or less provide equality between the tribes in Maine and the rest of the United States. A little bit of a historical background. The Settlement Act was the result of efforts by the tribes in Maine to enforce treaty obligations. The last treaties in Maine, I believe, were generally entered into in the early 19th century. I'm not sure exactly which treaties were last entered into between the Commonwealth of Massachusetts and the tribes in Maine, but we know that one of the very first treaties in the United States, a Treaty of Watertown, was entered into with the Wabanaki tribes in the United States. I believe that was in 1776, July 19th, just after the Declaration of Independence. Tribal efforts to enforce those treaty obligations, which were specific and distinct for each tribe, resulted in a lawsuit brought by the Passamaquoddy Tribe against the Secretary of the Interior at the time, Mr. Morton. And that lawsuit resulted in a recognition of the Passamaquoddy Tribe's essentially inherent federal tribal trust relationship, finding that the Passamaquoddy Tribe was imbued with the full panoply of sovereign rights that tribes anywhere else in the United States existed. In 1975, this was a very sweeping statement. Between 1975 and 1980, the tribes had brought land claims. The United States brought land claims against the state of Maine. The tribes exercised full sovereignty, criminal jurisdiction, civil jurisdiction over their lands to the extent that they still had them, and they were very limited. But in 1980, the tribes' land claims were settled through the Settlement Acts, as we will refer to them. The Maine Implementing Act is the state component, and that's where 2094 focuses. So what are the tribes seeking in Maine? This is about equity and fairness. The tribes are asking to have their sovereign rights respected and on par with the 570-something tribes around the United States. Since 1980, Maine tribes have been blocked from accessing laws passed by Congress to benefit tribes because of a provision of the Settlement Act. What 2094 would ensure that tribes essentially have rights that are equal to other tribes, and then moving forward, the tribes have the access to enjoy federal laws just like any other tribe. I won't go through all of the task force recommendations. There's a lot here. We're obviously going to focus on environmental regulation and the taking of fish and game, but I'll leave these up here and just paint a really brief picture about what the recommendations are about. With respect to criminal and civil jurisdiction, the recommendations would enable the tribes, through changes to the Settlement Act, to pass, write, and enforce their own laws with respect to criminal activities, civil activities, and that includes regulation of fish and game in the environment. It would allow the tribes to essentially act as a taxing authority, as the sovereign taxing authority within their lands, taxing activities that could be with respect to sales taxes or use of resources, and very significantly, to allow the tribes in Maine to enjoy the benefits of other federal laws passed by Congress for the benefit of Indians. That includes the Indian Gaming Regulatory Act. That includes provisions of the Clean Water Act and the Clean Air Act that enable tribes to regulate their own resources as states. And we'll get a lot into that a little bit later. And finally, there are several recommendations that would allow the tribes to essentially acquire trust lands and to fulfill provisions of the Settlement Act that have prevented the tribes from even acquiring the amount of acreage set aside for the tribes under the Settlement Act. So really quickly, a little bit of context for where the tribes are located. This map at a pretty high level shows you where the tribes' lands are. The trust lands here, this is, I believe, a map that came from John Banks' office. So trust lands in red are Penobscot Nation trust lands. And you'll see some pretty big blotches of red in a couple of scattered places, and pink, which are Passamaquoddy trust lands. That's just to orient you with respect to where the tribes would be exercising expanded jurisdiction. You'll note that you can't even really see brown Holton Maliseet lands, but they're up in the far right corner near where Holton would be. There's a brown speck up there. And a rustic band of Micmac lands are also very challenging to see. It just goes to show the scope of what was given up. Before we turn it over to John for a discussion of how the tribes would implement the provisions of 2094, their ability to essentially exercise their sovereignty like other tribes under 2094. I'm going to talk about the rules of federal Indian law that would more or less become applicable. These next two slides, I'm going to gloss over a lot that's here, and I'll make this information available to all of you. But what we're talking about in Maine is bringing the rules of federal Indian law that apply everywhere else in Indian country, at the Crow Reservation in Montana, the Navajo Nation in Arizona, Utah, New Mexico, the small little specks of land where tribes have casinos in California. All of these areas are generally subject to what we call the rules of federal Indian law. In the environmental realm, and in that's resources realm, this means that tribes are recognized as sovereigns that can exercise authority over lands and natural resources in their Indian country. When I talk about Indian country, I'm referring to reservation lands that have never been ceded, reservation lands set aside by federal law or treaty, or lands that are taken into trust, essentially to be held by the United States for the protection of tribes, that those lands can never be alienated. These are all Indian country, and I'll sort of use the words Indian country, reservation lands, and trust lands interchangeably. But tribal sovereignty under federal Indian law means essentially the recognition of tribal authority over lands and resources. These rights are presumed to be retained unless they've been specifically limited under tribal law. Obviously, the settlement acts are a significant limitation on how the tribes in Maine exercise their rights to regulate their environment. But generally speaking, the tribal right to regulate the environment comes from two inherent sources of law. Two sources of law. The first is inherent tribal sovereignty to the extent it has not been limited, and two, it is powers authorized by Congress under specific laws like the Clean Water Act or the Clean Air Act. Tribal nations are sovereigns, just like the state of Maine is a sovereign in this place where I am right now, and they are able to pass laws to regulate their territory in the same way that Maine passes laws to regulate its territory. This means that tribes can regulate to ensure environmental protection standards, and in doing so, tribes can establish comprehensive sources of law, ordinances, chapters of laws, hundreds and hundreds of pages at times, to deal with everything from the permitting of uses of land to drilling of wells, or to anything else that really deals with the environment. Regulating trash fires, just as an example. There are a number of laws that Congress has passed to regulate how tribes regulate the environment and how states regulate the environment. Tribes typically are dealt with alongside states when Congress passes laws such as the Clean Water Act or the Safe Drinking Water Act. Problem is, the Federal Indian Claim Settlement Act here in Maine specifically blocked the tribes from exercising the same exact rights that were being given to the state of Maine under those laws, the ability to regulate their backyards. So there are a number of laws that tribes would be able to, quote, be treated as a state under, and John will talk a bit about those. Just really quickly, the rules of federal Indian law with respect to the taking of fish and game. Again, these are the rules applicable elsewhere in Indian country, but these are the rules that are being proposed under 2094 to be brought into the state of Maine. No expansions from them. The goal is to follow the rules of federal Indian law. Just like any other government and just like the tribes can now, this means that the tribes would be able to regulate the taking of fish and game through hunting, fishing, and trapping within their Indian country. Tribes have inherent sovereign authority to exercise these rights on their reservation and trust lands, and this is generally exclusive of state authority. That is the rule of federal Indian law. The Supreme Court has held in a number of cases that states in limited situations, in emergency situations, can exercise sovereign authority to regulate activities on Indian lands where there's a threat to wildlife or to public health, and where that regulation is reasonable and necessary as a conservation measure. This more or less mimics, in a lot of ways, but not exactly, what's already provided for under the Maine Indian Claim Settlement Act. This also, under federal rules, means that absent a right that's been relinquished by a treaty or a federal statute, the tribes really are the sovereign that regulates their lands. Absent the relinquishment, the tribal citizens and the tribal members have the right to take fish and to regulate the taking of fish and game by Indians and non-Indians who voluntarily engage in that activity on tribal lands. This includes a regulation of taking of fish and game for consumption or sale. And these rights are ordinarily tied to specific treaty rights or to specific statutory rights that are set forth in federal laws. So at this point, I'm going to turn it over to John to talk about how the tribes might implement some of these rules of federal Indian law. Thank you.
Yeah. Okay. Thank you, everybody, for participating today. It's a wonderful, beautiful day out there, and I appreciate you taking the time to be with us here instead of being out there, which is probably where a lot of us wish we were right now. Yeah, Corey did a great job laying out the legal foundation of a lot of this stuff. So I wanted to talk about a little bit about what I think it would mean to my tribe in the conduct of our natural resources management programs. But first, I wanted to throw out, a question I think a lot of people have on their minds is, well, how did we end up like this? How did we end up in a situation where the tribes in Maine are the only tribes out of the 560 plus federally recognized tribes that don't have complete control over their lands and natural resources? And the reason is that just before 1980, when the Settlement Act and the Maine Implementing Act were being put together and being put out there, there was a lot of duress and a lot of pressure on the tribes to accept Maine's control, if you will, continued control and jurisdiction over the tribes that it had improperly or illegally exercised since 1820. And there was a lot of duress and pressure on the tribes to accept that at both the state and the federal levels. There was a town meeting in Bangor, Maine, which Jimmy Carter was doing. Jimmy Carter was doing a town meeting, and one of our tribal members stood up and asked him if he would veto the land claims legislation if he was reelected. And he stated that he would not veto it, or that he just would not veto it, whether he was elected or not. And so the tribes were very concerned that Jimmy Carter was going to lose the election to Ronald Reagan, which is ultimately what did happen. And so we were rushed. The tribes were very much rushed to get this through. And that's one of the reasons that we ended up agreeing to the provisions at the time of the Maine Implementing Act, which is the problematic part of the act. That's the state act that has language about Maine's environmental laws applying on Indian lands. So in the 1980s and into the 90s, I joined up with several of the national tribal advocacy organizations that deal with natural resources, organizations such as the Native American Fish and Wildlife Society and the National Tribal Environmental Council, Intertribal Timber Council, and all these national organizations that tribes have been working with for years. And I did that really to get an understanding of what other tribes are doing across the country, and in terms of their natural resource management programs. And most of these tribal people that I talked to were really shocked at what the situation was in Maine. They're like scratching their heads and they're like saying, like, what? Maine has regulatory authority over your waters? And they just didn't understand how that could be. And so anyway, this bill is intended to put us, the tribes in Maine, back on par with the rest of the federally recognized tribes in the country. And how that would affect what we do here at Penobscot in our natural resources program is pretty profound. Corey mentioned the Clean Water Act and Clean Air Act amendments. Well, as you know, I'm sure the federal laws, there's provisions that originally let's take the Clean Water Act as an example. When it was approved in what, I think around 1970, 71. And maybe it was amended later, but at some point they put provisions in there that allowed state governments to assume the authority to run these federal programs. They remain a federal program, but the operation of those programs is delegated to the state. And so states had begun assuming delegation of authority of many of the Clean Water Act programs, including the NIPDES program, water quality standards, the 106 program, which has to do with water quality monitoring. And so we started looking into that and found out very quickly from a lot of the lawyers in the government that the Settlement Act was a barrier to the Maine tribes being able to assume those programs. So I forgot a piece, an important piece, which is that in the 1990s, these acts were amended to also allow federally recognized tribes to be delegated these program authorities. And that was because EPA and the tribes recognized that there were these vast areas of where there was no recognized jurisdiction for implementing the Clean Water Act. About 3 to 4% of the land holdings in the United States had no environmental protection because the tribes retained sovereignty to administer and manage those lands and resources. And the federal government, up until then, hadn't amended those acts to allow tribes to assume those programs. So those acts were amended to allow tribes to assume those programs, which many tribes assumed those programs and took advantage of the ability to set their own water quality standards. There were some cases that went all the way to the Supreme Court. Down in New Mexico was the Isleta Pueblo case, where the city of Albuquerque had challenged their authority to set water quality standards. That went all the way to the Supreme Court, and EPA and the tribe, or the Pueblo, won that case. And the Isleta Pueblo put in water quality standards to protect their members' use of the waters in the Rio Grande. And that happened to be downstream of Albuquerque, so Albuquerque was forced to make some major tweaks to its, its municipal waste management systems to provide for standards to be met that the Isleta Pueblo had established downstream. And then in Montana, there was another case with the Flathead the Flathead tribe. They also moved to enact water quality standards to protect their members' use of their water resources. And that was challenged, I think, mostly by the agriculture industry and the irrigators. And that went all the way to the Supreme Court, and the tribe and EPA won that case as well. So here in Maine, we've been spending hundreds and thousands of dollars of your money, taxpayers' money. EPA has been spent, the state of Maine, and we're all in this big fight, spending all this money about who has the authority to set water quality standards. So, meanwhile, our tribal members are trying to continue their cultural and traditional practices on our waters, and it's just a big mess. We're in court now, and on several of these issues, and it's just not to say anything bad about my attorney friend Corey, but only the lawyers are winning. The rivers aren't winning, the people aren't winning, the industries and the towns that discharge into these waters don't have certainty for the future, and the paper industry and other industry folks are very good at putting fear into the public, saying things that, if the tribes have control over our own resources, that the sky is going to fall and they're going to have to spend millions of dollars complying. And that's just not true. I mean, that's a bunch of fear mongering they're very good at doing. So that's on the Clean Water Act water quality standards issue. And we don't have a lot of time today, and any one of these subjects could certainly take a whole day or more to dive into. So I'm going to leave that one there for right now. Certainly, if there's any questions, we can come back to it. But I'm going to talk a little bit about the Fish and Game provisions. So in the 1980 Settlement Act, one of the areas the only areas that's clear where tribes have their own authority is in the taking of wildlife. So there's language that supports that, you know, the tribes have the authority to regulate the taking of wildlife on their tribal land. So at Penobscot, we have done that since 1980. We have a whole system of enacting fish and game regulations. And, you know, that includes sustenance regulations for tribal members. And, you know, the body of state law isn't bad. I mean, Title 12 isn't, you know, there's a lot of good stuff there. So our tribe, Penobscot, has actually adopted all of Title 12 as a backdrop to our tribal fish and game laws, so that, you know, giving our game wardens as many tools as we possibly can to allow them to efficiently and effectively, you know, enforce fish and game laws to protect our fish and game populations. So we've been doing that since 1980. That's already in place. So there's not a lot of changes that would result from LD 294 in terms of fish and game regulations. So yeah, Title 12 is the state of Maine's inland fish and game laws. I think somebody had asked that question. So that's state law that the Penobscot Nation, at least, I don't know if the Passamaquoddy have as well, but the Penobscot Nation has adopted all of Title 12 as tribal law to apply on our lands. And, you know, we didn't want to reinvent the wheel. Like I said, there's a lot of good stuff in Title 12. So we turn to Title 12 whenever, if we don't have a regulation or a law that addresses, you know, whatever we're talking about. You know, we have our own seasons and bag limits and so forth, but we rely on Title 12 for many other things. So, you know, like I said, this stuff can get complicated and we can get down into the weeds really quickly. So I wanted to get to the Q&A part of this as soon as possible, since we only have an hour together. So I'm going to leave it at that for now, and hopefully we'll continue this discussion with some questions and maybe even some answers. Thank you.
Thank you very much to Corey and John. So now, what can you do? You can contact your state legislators and urge them to support LD 2094. The link is in the chat. And stay tuned for future information about how you can support the newly formed Wabanaki Alliance's efforts. And we are going to go to questions. See where they are. Sorry, gotta get them. Okay, so the first question is, how, if control of water quality regulations and enforcement under the Clean Water Act is delegated to the tribes, what changes do you anticipate to water quality regulations on the Penobscot and the St. Croix rivers?
Well, that's hard to predict precisely or specifically. We would go through our normal process of setting rules and regulations which, it's a process that does allow for folks outside of the tribe to comment on. We would have a public hearing when we propose new regulations. But I suspect that, similar to what we did with Fish and Game, that our tribe would probably move to put in place what's in place now under state law, so that we don't have a void of any regulations being in place. So my suspicion, and I can't say for sure, but I think our tribe would adopt state environmental laws as they pertain to water quality standards, and then perhaps tweak them down the road as our tribe gets used to, monitoring and enforcing these new regulations.
Okay, thank you, John. How are you working with the Mills administration on this legislation?
That sounds like a question for Corey. I'm not real familiar with that.
Well, let me put it this way. John Banks is the head of the Penobscot Nation's Environmental Department. And if there was somebody that was going to be engaging with his counterparts in the state of Maine, it would be John Banks. I guess what I'm trying to say is we have not been able to engage the state on any substantive issues outside of a very, very limited few. So the tribes for quite a while prior to the pandemic had requested meetings with the Commissioner of DEP, the Commissioner of Maine Revenue Service, the Commissioner of Marine Resources. None of those meeting requests were ever granted. The tribes did have one meeting that they were invited to with Governor Mills. The tribes had specifically requested it for the purpose of discussing path forward on LD 2094. And when they arrived, there was an agenda pre-printed for them, and there was no discussion of 2094 at all. So I guess it's been challenging to have a substantive dialogue with the governor's office. I would say, though, that the day or two before the pandemic really shut things down, it's like March 12th or 13th, lawyers for all of the tribes met with the Attorney General's office for 4.5 hours. We rolled up our sleeves. We did our best to socially distance in a conference room. And we went through issues where we felt legal clarity was needed to rein in legislative language to make sure more closely reflected the intent of capturing the rules of federal Indian law. It was a very, very constructive meeting, the most constructive meeting that I have ever had with the Attorney General's office. I mean, 4.5 hours. Try doing that with anybody. I mean, yeah. it can be hard, but it was like 10 lawyers in a room, and it was really remarkable. At the same time, while we weren't making traction on 2094, the state tribal governors and the tribal attorneys negotiated changes to bring the Violence Against Women Act to enactment in Maine. That was significant. So we're finding lanes where we can work with the administration, but we're not having a consistent substantive dialogue around 2094. There are some parts where we think we can find a resolution, though, so we're still optimistic about moving forward.
Great, thank you. And how does management of rare, threatened, and endangered species fit into this?
Well, so essentially the rules with respect to endangered species, whether we're talking, specific laws for specific animals or, more larger umbrella laws like the Lacey Act, for example, all of those laws will continue to apply in Maine, just like they do now. The tribes are often required to be complying explicitly with these sorts of laws. There are often provisions in those laws, however, that provide certain exceptions to, say, the handling of certain species by indigenous people, whether it's, the carrying of eagle parts, or whether it's, obtaining endangered species for sustenance. That's extraordinarily important. So all of those rules that are applicable everywhere else in Indian country will continue to apply in Maine. That's, those rules account for indigenous use of species, just like they do every other citizen. And all of those rules that are out there would be applicable in Maine.
Thank you. And how would LUPC regulations intersect with tribal regulations?
They would not necessarily. The LUPC, though, when it comes to infrastructure, one of the big things that the tribes are trying to emphasize as a part of LD 2094 is the need for local government to government, neighbor to neighbor cooperation. And so when it comes to utilities, oftentimes what happens is tribes are, when they're receiving water or electricity from, off-reservation utilities, just like every other community, you pay for that service. There's no need for any services to change. It's not like when you go to reservations out west, the electricity lines end when you get to the reservation borders. All of the state of Maine's regulatory infrastructure for off of the reservation would exist. The tribes would have the opportunity to negotiate and implement their own policy frameworks for the regulation of on-reservation utilities. When it comes to existing frameworks, I don't think the idea is for, one day we're living under this regime and then the next day the tribes are cutting telephone poles and, allowing everyone to go fishing for orca whales. That's really not what this is about. This is about having very close-knit working relationships with neighbors, with utilities, and with state agencies. A significant part of LE 2094, which for some reason has been kind of glossed over, is the fact that the tribes are trying to demand mandatory consultation between the state agencies, the state commissions, and the tribes on all issues, whether we're talking about the LUPC, whether we're talking about DMR, fish and game, environmental protection. Right now, there's no framework for the state of Maine and the tribes to consult. What that means is that in the state of Maine, that there is a very, very long history of the state of Maine acting unilaterally striking down state regulations, unilaterally driving trucks and highways through the middle of reservations, unilaterally damming our lands to build bridges. So what this legislation is going to do is require everyone to talk about, when the need for infrastructure, or when the need for a use, the need for a utility exists, all of the governments are talking to each other and working that out through a public process.
Thank you, Corey. It seems like much opposition to LD 2094 comes from fundamental misunderstanding and lack of knowledge, including among legislators of the tribes, Indian law, and the Settlement Act. What efforts are underway to educate legislators?
This is a great question. There was a mention in the call to action about the Wabanaki, the new Wabanaki Alliance, and I think that's a greatest symbol of what the tribes are doing. I think that everyone knows, but if you don't know, the Wabanaki Confederacy, it's a political alliance between the Passamaquoddy, the Penobscot, the Abenaki, the Micmac, and the Maliseet on both sides of the border. It's most active, in Canada as a formal entity. In the United States, right now, we're engaging with among the tribes and with the state in a political, an act of political diplomacy that is quite unprecedented, and it's essentially forced the tribes into the need to create an organized source of communicating and educating policy leaders and Maine citizens. So the Wabanaki tribes have formed a 501c4 called the Wabanaki Alliance, and then there's going to be a political action committee that will also separately be formed. The specific purpose of these groups, first and foremost with the C4, is to educate lawmakers. The purpose of the political action committee will be to conduct fundraising to further relationship building with elected officials in advance of elections, lobbying and trying to really make sure that the people that are being elected know that tribal issues are important, and to really spread the message of what the tribes are trying to do with respect to tribal sovereignty. That effort, the Wabanaki Alliance, is going to have a website in the next couple of days. And so we'll be sharing that information that's going to be the body. It has directed representation of all the tribes. That's going to be the body doing a significant amount of outreach in the next few months.
Great. So Corey, there are lots of, and John, there are lots of questions about the status of LD 2094. What can people do to help? Will it be taken up during the special session if there is one? If it's not taken up, will it be introduced next year? Lots of questions like that.
And I don't know the answer to those questions. I've been asking that myself. I think it's unanswered at this point. I'm not sure. Corey, do you have more information on if the legislatures?
Yeah, there are no concrete answers. I think that a lot of people are hopeful that LD 2094 would be considered in a special session. We have some signals, I think, from leadership that this is a pretty big priority for many of the people in legislative leadership. So we're hopeful that this will be a part of a special session. That's unclear, though. What I've been told is that when it comes to special sessions, they're pretty much being called by the legislators, and usually, they're not always ripe for what might be viewed by some as controversial issues. So we think that there are efforts underway to limit the sorts of issues that would be involved in a special session. And so we don't know if that'll happen. We are pretty hopeful, though, that if nothing happens before the elections, that this would be carried forward into the next session through whatever means necessary. We are building pretty significant political momentum as far as I'm concerned. So if we can get something done in a special session, great, but we're going to keep coming back here because we're trying to accomplish intergenerational change.
Thank you. So here's a question from Peter. He says, I am appalled at what a tiny portion of Maine's area has been labeled as tribal lands. Do you have suggestions on how lands can be added, especially with Maine increasing its proportion of concerned lands from 6 to 20% in recent years?
John?
Yeah, I'll take a stab at that. The Settlement Act provided for the Passamaquoddy and the Penobscot tribes to each acquire up to 150,000 acres of trust lands. And both tribes are working toward that goal. But there's other processes in place as well that would help the tribes in gaining access to some land holdings that are important to them, or having use agreements with existing landowners to access lands for cultural and traditional gathering purposes. I want to alert everybody to what's called the First Light Learning Journey, which is a coalition of land trusts and tribal folks that are working together to accomplish some of those things that I just mentioned. So there's a website if anybody wants to follow up and look at what the First Light Learning Journey is all about. I would certainly encourage them to do that.
Okay.
Could I follow up on that, Beth?
Sure, Corey.
Yeah, so I think John hit the nail on the head. It comes down to local cooperation and these landowners all agreeing that the tribes acquiring land in respectful ways is not going to be upsetting the fabric of local communities. But we need to be clear about why the tribes, to a large extent, haven't been able to acquire the amount allowed under the Settlement Act, and it's maybe like 2/3 of that each tribe has acquired, maybe 2/3. So there's quite a bit still left on the table, so to speak. The Settlement Act allows that a government, either the state or a local government, has veto power over any efforts by the tribe to put land in the trust. And so it means that, historically speaking, when tribes have wanted to put land in the trust, they either have to go to the legislature and try to get a bill passed, or they need to go to local governments and sometimes lobby in local referendums and pay exorbitant sums of money to put land in trust. We're talking, acres next to the reservation to build housing. That's what's been extracted, literally, ounces of flesh and a lot of money. And quite frankly, that process has been offensive in many ways to us. You see land prices inflated and all of that as well. So in the Settlement Act revisions that are proposed, the notion of local and state veto over land acquisitions within Aboriginal territories where the tribes have been historically, we've eliminated that. And we're hoping that that this will allow the tribes to reacquire, what was agreed to under the Settlement Act. And then there are 70, 80-year-old federal laws that govern how tribes everywhere else in the country acquire additional land. And the tribes are essentially proposing, allow us to fulfill the Settlement Act, and then we'll submit an application to the federal government and consult with local governments every other land acquisition after that. And these are essentially the rules of federal Indian law. So, that's the mechanism. But, obviously land acquisition is expensive. And so, there are a lot of complications around, the acquisition of lands.
Okay. Thank you very much. We have two questions about water quality. The first is, if the tribes had authority over water quality standards, how would that affect the waters outside tribal lands, upstream and downstream of Indian lands? And can you speak about any changes to rights or sovereignty to bodies of water in and around tribal lands? Are there any connections to ocean and fishing there?
That sounds like a Corey question as well.
What comes part and parcel with the tribe's a sovereign's ability to regulate its water sources, its natural resources, is the ability to set water quality standards. There are examples that John mentioned of situations where tribes have passed water quality standards more stringent than those in surrounding areas. And what that's resulted in is a reckoning between those who are demanding additional water quality protections for human life, and reconciliation with those who are discharging into waters. I am not going to say what any of the nations will do with respect to their sovereign powers that they may or may not obtain, but I will say that everywhere in the United States where tribes exercise these powers, what you see are efforts to improve the quality of the environment. So, that's just what the tribes are looking to be able to do. And in some situations, the tribes may deem that there is a more stringent environmental standard that's necessary. I think generally speaking, as John alluded to earlier, what you're likely to see, if I would just pull out my crystal ball, and I can't say this is what the tribes will do, but I think that largely you're going to see the tribes wanting to have standards that work with local governments, and that are completely cohesive with their neighbors to avoid conflict. I think we have to keep in mind that the Wabanaki, the Passamaquoddy, and the Penobscot, the Micmac, and the Maliseet, we were here and protected this land. And when people came here and needed to survive off of a land, we showed them how. These were our neighbors, and these are the relationships that we've been, trying to promote through LD 2094. We are the ultimate good neighbors. And we will continue to be the good neighbors. This isn't about regulating our neighbors' businesses out of existence, but this is about ensuring that there is an environment that we can live in, and that allows the fish in the game that we need to rely on to be healthy for the next several generations.
Yeah, and if I could just add that, speaking for the Penobscot, contrary to popular belief, we're not, our goal isn't to shut every single mill down on the Penobscot River. We're part of that forest economy. We have tribal members that work in these mills. We have, I have 130,000 acres of forest land that I need markets for in order to be able to sell, the trees, the products that our forest management plan requires that we harvest every year. So, we're not out to shut down any mills. We are very much interested in encouraging and doing what we can to encourage more environmentally friendly manufacturing processes. There are paper mills in other parts of the world that have closed loop systems, and unfortunately, a lot of our mills are so old that it's difficult financially for some of the mills to be able to make these changes. Yeah.
Thank you for that. We have two more questions. How can youth organizations and coalitions like Maine Youth for Climate Justice plug in and help to amplify and assist the legislation?
I'll try that on. I would say that what the Wabanaki Alliance is going to be doing over the next couple of weeks. They just formed maybe like 3 weeks ago, and there's a board of directors. It's run by Molly and Dana. What they're going to be doing is organizing, volunteers who are willing to literally lobby in Augusta. We need shows of force in terms of, the public support and the positivity behind our message and what the tribes are hoping to be able to do in exerting their tribal sovereignty. The Wabanaki Alliance is going to be fundraising so that they can fund their own activities, fund the travel for the tribal leaders to get to Augusta, fund the, I know for some of the tribes up north, Augusta is pretty far and it's a real challenge to bring people down, and we want to be really active. So we're trying to really build a network, and Wabanaki Alliance, and we'll put everyone who's on this meeting in touch with the Wabanaki Alliance's website once it's up in a couple of days. They're going to be driving the force, and I would strongly encourage people to get involved, volunteer, and help us lobby for the passage of 2094.
I think, well, I think you answered this question. The next one was, assuming that the Mills administration continues to maintain its current posture on LD 2094, what do you think will be needed to get the bill through the Judiciary Committee and then enacted by the legislature? And I think you just answered that, Corey. It's going to take a show of force, right? And all of us getting involved.
I think so. I mean, not to be, cute about the Maine legislative process, because I don't understand it, but we're going to get through the Judiciary Committee. I think the legislative dynamics are such that with significant numbers of Democrats in both chambers, we can probably pass this and bring it to the governor's desk. She's most likely to veto it, though. We think that there are areas where we, in theory, where you might be able to develop a veto-proof majority, or simply have, a limited version of this for right now that the governor can support. So there are paths forward, and we hadn't really gotten to the point in the legislative process where the sort of horse trading had started. No one was negotiating with us. We were improving the legislation, working with the AG's office, and I think there's a lot of work to be done between the chiefs and the governor. That's where the work needs to be, and we hope that can happen between now and the election season.
Great, thank you. We received lots of questions today, and apologies for all of those that we couldn't answer. We hope that there'll be an opportunity to engage more, and it's obvious through the chat that people are very interested in helping out. So Corey and John, thank you very, very much for your presentation. I think we all learned a lot, and you're wonderful. Thank you.
Thank you so much.
Thank you all.
So we're about to wrap up. There'll be a short survey sent to you in an email today. Please take time to fill that out. We'd love your feedback. And please join us for next Friday's Lunch and Learn. That's June 26th from 12 to 1. The topic is Equitable Transportation Solutions. Angela Johnson Rodriguez will present that. We're going to be off on July 3rd, but we'll be back on July 10th. From 12 to 1 to learn about climate change, environmental justice, and the Wabanaki tribal nations with Professor Darren Ronco. So that is it. Thank you all very much.
Thank you all. Thank you for your questions.
Thank you, Corey. Thank you, John.
Thank you very, very much.
Thank you for thanking me, and thank you. Have a wonderful weekend, everybody.
You
Bye-bye.
too. Bye.